One of the problems that people run into in the course of their cases is that they act as though the other party, the party who's responsible for taking care of them, is actually going to do the right thing for them and by them in the course of the case. Let's say, for example, in a workers' comp case, that you fall down at work and that you're transported by ambulance to a hospital. Well, your employer knows or should have known or reasonably knew that you were injured in the course of your work because you were transported from the scene of the work site to the hospital. But let's say in the sort of opposite scenario, let's say that you suffered a back strain on Friday afternoon at work and that you never actually went to your employer and told them, hey, I suffered this injury. I was lifting a pallet and I strained my back and I'm in a lot of pain here as a result of that. And then you come back on Monday morning, you resume your work, but you're still kind of hurting. And let's say that time goes on and your back just progressively gets worse, but that you never actually go to your employer within that 30-day period or give them writing within that 30-day period that you suffered this injury and that you were hurting and that you were hurt as a result of that work that you did on the job. If that's the case, well, then your employer has a pretty good defense to your workers' comp case that you never, in fact, gave them notice in the 30-day period as required by our law. So you want to make sure that during the 30-day period and immediately as soon thereafter, that you send an email, write them a letter, give them notice that you were in fact hurt on the job, request medical treatment from them as a result of that injury. That way you remove all the possibilities and you remove the other problem, the other defense that they're going to raise whenever you don't give them notice immediately at the time, which is that you didn't in fact suffer the injury on the job. So in that scenario where you're hurt on Friday afternoon, you strain your back, you don't go to them, you don't send them an email, you don't write them a letter that says, hey, I was hurt on this date and I need some medical care as a result of it. They're going to come back later on, and not only are they going to defend the case that you did not give them timely notice of the injury, but they're also going to say that you weren't hurt in the course of the job, or that you need to prove as a part of your burden of proof that you were in fact hurt on the job. So eliminate those possibilities, eliminate those difficulties by just dotting your I's and crossing your T's and tying things up neatly. And you do that by putting it in writing. We always say, like, if it's not in writing, it just didn't happen. So eliminate that possibility, eliminate those defenses from them. I hope that's helpful for you.